How to win slip and fall cases. Slip and fall cases are hard. Slip and fall cases boil down to the fact that a person has slipped or tripped on a hazard on a property. Here is a typical way a slip and fall case plays out. The property owners and managers deny there was a hazard, and it wasn't there. If the hazard is shown to exist, well, they're going to deny they knew about it or should have known about it. Oh, well, it's wet, but we didn't know about it, or it just happened too soon for us to do anything about it. When we prove that they knew or should have known about it, property manager or owner will say, well, the injured person is exaggerating or faking their injuries. Once we prove the person was really injured, the landowner or manager often says, well, the injured person is at least 50% at fault because they had a responsibility to look where they're walking. All of this is nonsense, but it is nonsense that we as injury attorneys deal with every single day when handling slip and fall cases. Now, just because a case is hard doesn't mean it's impossible. And in fact, the lawyers of the Marc Lopez law firm, well, we enjoy a good challenge. Success in slip and fall cases comes down to a few different things. Eyewitness testimony. Obviously, it will help if you were shopping at the store you're injured at with your significant other or friends, but there may be other witnesses available, other shoppers, and even the employees themselves who were present and rendered aid or help or took information. The testimony of friends, bystanders, or even employees can significantly help your slip and fall claim. The incident report. If you are hurt at a store or other public place, it is likely there's going to be an incident report that's created internally that will indicate the person responsible for the property, the possible witnesses, and then even corrective action that was taken so it doesn't happen again. And you can guess, stores aren't too eager to hand these reports over to attorneys. But when your attorney obtains it, it's often very helpful in the slip and fall case. Security footage. Security footage is typically helpful in determining exactly what happened. But naturally, stores fight tooth and nail to not disclose the security footage. That's okay though. As an attorney, I have the power to ask the courts to make them provide this. And if a store tries to get cute and gets rid of the footage, well, that looks even worse than not handing it over in the first place. Medical records. Your medical records will indicate what types of injuries you sustained. And oftentimes, doctors will put in the medical records if these injuries are consistent with a slip and fall type injury. Going to a doctor after a slip and fall incident is so very important. And do it immediately. Any delay in obtaining medical treatment can be used against you by the landowner or the manager, saying you made it worse by not getting treatment sooner. Property maintenance records. Maintenance records, or even the lack of maintenance records, can help establish that the property owners or managers knew or should have known of a hazard. Maintenance records are so very important when pursuing a slip and fall claim. Slip and fall cases are hard, but they're not impossible. And the Marc Lopez law firm never backs down from a good fight. If you or a loved one have been injured in a slip and fall case, call us, 317-632-3642. We will help you obtain full justice.